Without further ado, here is Frank May.
Thank you, everybody, giving me a chance to come to your chamber to address the issue of every economy up and down. Eviction is a part of the real estate market. Somebody selling the house, somebody renting the house. It must be somebody not paying the house, the rent, or not moving out after sale or before the sale. So this topic is never go away. We know that. The better economy is bringing more people, real estate owner willing to sell the property, and some tenants is hard to find the proper location to go. There's a legal way to go about to get them move up legally. So today's topic is mainly concentrated on how you guys serve the proper notice and give a property notice to the tenant or occupants. Now the term of tenants and occupants divided in the legal terminology that a renter under the contract or non-contract basically paying rent. So therefore, it constitutes that the landlord have right to demand payment of rent within each rental period. However, if the money not paid, that landlord can and legally giving a notice to pay rent quick. It's a 3-day notice basically. Now in commercial area, I was talking about commercial, it depends on the lease itself. Generally speaking, 3-day notice is the form that will be used. In commercial, it could be a 5-day notice or 10, 15 days, depending on the contract signed by the parties between the property owner and the tenants. So today's topic, we're going to cover the overall of this process. The most important part as the real estate agent, managers, owners, is how to approach the tenant legally and appropriately without any, before we take a case to the court. Obviously, this company will handle the eviction day in, day out. That's what we are here for. Therefore, your job is giving the proper advice to your client and then give a proper notice to the party that living in the complex. So starting from this point on, let me introduce myself. My name is Frank. I guess everybody should by now know me. I've been here every year to give address to this chamber that what is the new law, what's moving forward, but ultimately it's the same effect on any proceeding. If you look at this pamphlet that I provided, the first page that I was produced is a 3-day notice to pay rent quick. For tenant who responsible for paying rent, either contract or non-contract tenancy require a proper notice after the due date. Now, when we're talking about due date, let me expand that a little bit. Rent due generally on the first is not defined by, well, we just using that as the example. And delinquent on the second day of the due date. Now the second day of due date, depending on the holiday or not, the detail of the due date determined by the lease, which is due on the first. However, the due date doesn't come on Saturday nor Sunday. It has to be a first banking day. So if the first day of the month is on the first, is on Sunday, then the due date will shift to the second, and not delinquent until the third, the Tuesday of the week. So that's important. When you serve the notice, you want to serve the notice after the due date to pay rent quick. So basic premises of a notice consisted of perform a quick notice, which is, I did not attach it, is require a lot more detail on that. Somebody who violated the lease, have a pet, have a dog, or any parking violations, therefore you basically have a written contract that not perform according to the lease. The other scenario is the tenant violated law. The police was called, report was made. That could be a violation as well without it. Under the lease or non-lease, you can always serve a 3-day perform a quick notice. Now on the trustee sale front is that when you purchase a property over foreclosure sale, the first thing you have to record your deed. They call it trustee deed. After recording it, you have to give a 3-day for the ex-owner to move out. State of California also stated that if an ex-owner have a tenant in the property, you gotta honor that as either the lease or the short-term tenancy require a 60-day notice, 90-day notice, to be addressed. So this 3-day notice on a trustee have to be accompanied with a 90-day notice for unnamed tenancy, which is, we don't know who's living there. Initially, when you purchase property through foreclosure sale, you basically purchase property that ex-owner was in the property. That's what your expectation. Now, when the notice served, you have to accompany that 90 days. If anybody here living there have the right to report it to you, and then you give a proper measure whether or not you want to continue to rent it to them, accept the rent from them, or tell them to move out in 90 days. So that's depending on the scenario. So I did not attach that form either. Call me or anytime I can forward to you. The next one is the month-to-month tenancy that either after a year or less than a year. Whenever you have a month-to-month tenancy that the tenant did not violate any rental rule nor not paying rent, you have to give them a 60-day notice to move out. Now the 30-day, the form that I provided on this pamphlet, the first one, is a tenant who will live there less than a year. Most of the cases is a landlord renting a room to somebody else and a short-term rental, and the landlord and tenant relationship gets soured, and you need to tell them to leave. You have to give them proper 30-day notice. If a tenant was residing in the property more than a year, you have to give them 60 days. So the following page is the 60-day notice to termination of tenancy. Well, now we already covered all the notice that will have to be prepared, which is a form, self-describe it, you just have to fill it out. Now we have to know how to serve them properly. The tenant on 3-day notice, 60-day notice, 30-day notice, perform a quick notice, require a personally deliver to the property. When we just say delivery, it doesn't mean that you have to knock on the door and find somebody that you can give it to. So that is 3 ways to serve the notice properly. If you name John Doe in your notice, you gotta serve John, not Johnny. Now the notice have to be excludes any resident who was underage. So if you know that the adult resident in there's a name, you should name in your notice. Now 3-day notice, pay rent and quick have different criteria. Individual husband and wife paying rent to you, however, they have a cousin who living there that later brought into the property or not signing the lease. It just say, okay, occupants. That occupants, tenants do not responsible for the rent according to the lease signed or according to the payment term condition when they move in. Therefore, if you have a husband and wife in the property under the lease, and they bring mother-in-law, brother, son, or anybody else as an adult into the property, should name them. That's subject to a motion to strike, they call it. When you file the lawsuit against somebody who not named in the contract, no one responsible for the rent. So I suggest that not name them. Now, it doesn't mean to name more people is better than less people per se. It's just a matter of who was responsible for the rent. So they have less chance or less way to delay the case by filing a certain motion to delay the process of eviction proceeding. Now, each time the defendant files a certain motion to eliminate the name of the contract, the mistake was made in the complaint, or the legal entity of the property owner, it will be a hearing to be set, and usually take up to about 6 weeks. Along the line of eviction, 6 weeks is just an add-on to the delay. Normal process take about 3 months for one trial. So you can imagine one motion is just slightly in between of it, add another 6 weeks on the process. So for not making such a mistake, give us advantage for timely remove occupants from the property. I want to address the 24-hour notice a little bit, because this is that most of real estate agent or seller or buyer was a concern. When you do have a property for listing, the first thing you would recognize who living there, and how you go about it. I understand that you shouldn't disturb them, you shouldn't harass them. According to the California law, you have to give them proper notice in order to be there. Let's say if you want to inspect the property, for instance, 24-hour notice is one of the ways to do it. But it's very limited. It's not an unlimited scenario. It's only have a 12 reason that the landlord can approach the tenant and legally ask for a 24-hour and entry the property. Now, this notice has been changed over the year. Come to this point, it was a very strict that the landlord had to get a permission from the tenant before entering the property. You can't just get a key or locksmith forcibly entry the property without, even though you serve a 24-hour notice. If a tenant wasn't there, find out why and how. I'm not suggesting that you just get a key and go in there, except the special circumstances. For instance, the city inspector were there on the day that the notice was described. The tenant is not there. For any reason, they have reason that they purposely not to show up, or they have an emergency that not there, but however, the inspector have to go in there to inspect the property. Do it in a cautiously way, that giving, you have a spare key to go in there, it's great. If you have to, get a locksmith to open the door, not damage the key chamber. You have to legal entry the property. And I suggest that, of course, you will entry somebody in the living quarter. Power coming with a responsibility. Anybody that walk in with you that's stealing somebody's belonging in the house is subject to a lawsuit from the tenant against the landlord, or agent or manager who bring the third party into the property. So very costly advice. Now, let's say move on the change ownership. When you change the ownership after you took possession of the only owner, go ahead, give this form and fill it out and give it to them. Most of the likely, the tenant will continue living there, paying rent to the new owner, which is a necessity by law. The last but not least, when we moving for service, they have notice to be served 3 ways as described. You either post one and mail one copy out, just like that. Tape on the door, take a picture, United States Post Office, first class mail. They call it certificate of mailing. This is the post office will deliver the mail, drop in the box, give you a stamp, what day you mail it out. Post and mail, it's hand by hand. You have to do both. That's one other way, and maybe this is the best way, because you have both proof. You have a picture to prove that you tape it on, you have proof from the post office. Now, we're not advised using certificate of mailing. This question comes up quite often. If a tenant did not sign a certificate to return, that letter did not deliver, or that notice will take it back to the post office to return to you. So, certificate of mailing versus certified mail is a completely different ball game. Without challenge, you walk away. If the other side challenging and the court look at it, it could lose the case based on the notice was served. So the lawsuit itself consists of after the notice was served. That's our job to take the case to the court. Our attorney has specialized in this area for many, many years, and we process an average of about 70 to 80 per month. So approximately about 1,000, more or less than 1,000 per year. That's the way I legally have the sheriff down there to get them out. So you file a lawsuit, the defendant filed the answer, we go to trial. From the day we file until the trial, approximately 45 days, except in the motion was in between or bankruptcy. After the trial, we win the trial, we should. If we follow the protocol that what I described, then it takes about 45 days before the sheriff to knock on the door to get him out. Why is it too long? Everybody know? Well, the court just needed to process, and the sheriff will take about 3 to 4 weeks to reschedule. So, ownership on this page here that I provided is numbers of ownership can file the lawsuit. LLC, trust, corporation, anything under the title, not my name, not agent's name, have to be person entitled. So anybody who have any question, give me a call and we go over the more detail or specific. And the last one, I guess I should probably the time's up, is they call it itemized security deposit. When tenant move out, landlord obligated to give this notice, how you handle your their security deposit without giving the tenant proper notification subject for return full amount, even though they damage your property or own the money to you within 21 days after tenant vacated. I have a last page that I have a question. Does anybody have a specific question that I would answer 3 questions? Anybody? Specifically, yes, sir.
When you change the parking, let's say they've been more than a year, how many day notice? Like I want to eliminate a parking space for a tenant.
Change the parking space under the lease, you can give a 30-day change the term of tenancy. They have a specific form that you can fill in.
Thank you.
Next. Anybody?
What about rent control areas?
Rent control area is a big topic. I don't think we can cover that, but in general speaking, you can go online. They call RSO Los Angeles. Rent control basically create a long-term tenancy. They call it a light stay. Somebody will move into your property, a rental property, that built before 78 and more than 1 dwelling. 2 tenants, basically. It's subject to rent control. You got to register each year and you got to pay the fee. Now, this kind of thing, they call light stay. When they move in, they stay until they die.
Yep.
Nothing you can do about it.
Yep.
Except, if you want to say, I'm moving one of the unit, they don't call eviction, they call relocation. From $7,500 up to $20,000.
Crooks.
I relocate a few over the year. I mean, each year I always got some. I get called every week basically that have this subject. So I deny 75% of the case that I can do because nothing I can do about it. Yes,
Do you recommend cash for keys?
that's the only way probably. No. Cash for key is not a magic procedure. Think about the people you get cash without the legal proceeding. You create yourself, let's say they entitled for 20 grand and you give them $10,000. Later on they find out you violate the city ordinance. They can go back to the board, rent control board, and complain about it. And guess what?
So when? Liberal.
You have to pay.
Liberal judges.
Not only the judge, the board gonna take all over. That's it. Yes.
Is Section A inheritable? Like,
Yes. Any tenants that inherit from one tenancy to another is inheritable, except now Section A have a Section A rule, which is ruled by Section A board. When the landlord and tenant create a Section A agreement, basically the person have to be qualified. So this my family who qualified it, it doesn't mean that they move out or they bring their brother in is qualified also. It depends on the qualification because Section A is state or government subsidized rent. Let's say $1,000 rent, the Section A was giving $800 paying rent, the tenant only responsible for $200 per month. That's what the Section A is all about. Any question? Yes?
So like in case the tenant bringing a housing Section 8 application, what's the right language? We have to reset that.
You can or cannot accept that. If you do accept that, you have, as the landlord, you'll be scrutinized by Section A contract. They will send the inspector. They have to approval for a candidate. They have the approval for a landlord. And therefore, you will get the money after you accept it. It might take several months. I guess this is the last question, okay? Gentlemen, yes?
About the cash for keys concept. So, I mean, if you have the tenant side of the lease, I mean, that should adopt your manual language for the.
That's a two-part of question. First part, cash for key mean you move out emptily, I'll give you money, which is pre-agreed or afterward. It depends on situation. Secondly, release liability part, it depends on the tenant willing or will not willing to settle and sign that agreement. They call it global settlement. Most attorneys have that capability to prepare the contract. Doesn't mean the tenant can or will accept. If you pay them $3,000 to relocate, to move out, versus $20,000 that they want, that's two different ballgames.
So if they sign it, then.
If they sign it, this document is for protection, yes. And you do have to do it properly. I suggest that you have fine-tuning to get it. Thank you, everybody, and I'm here for a few minutes if you have questions.